All right, here we are. Welcome. I'm Rebecca Gray. This is our, before you include that arbitration clause, virtual coffee, here with Margeaux Thomas. The Entrepreneur's Lawyer is a collection of resources and information for geared towards startup general counsel. And I'm really excited to have Margeaux here because she has sort of a litigator's perspective on what you might be considering as you're trying to include an arbitration clause or say, maybe not. So Margeaux, why don't you introduce yourself?
Thank you for the invite. I'm excited to be here. I can tell you a little bit about myself. I started out in big law a little over 10, almost 15 years ago now. And I represented mostly banks and big business in disputes that they were having with consumers, a lot of credit disputes, debt collection issues, issues having to do with mortgages, a lot of litigation in federal court dealing with those type of consumer big business disputes. And then about 5 years ago, I started my own firm and I represent small businesses in contract disputes and business divorces. And that has gotten me into court a lot, doing a lot of motions practice, a lot of mediations, a fair amount of arbitrations to resolve these disputes.
Talk about the split of your practice at this point. How often do you end up in arbitrations?
So arbitration is not as frequent as we end up in mediation.
Yeah.
A lot of our clients elect to voluntarily go to mediation to try to resolve their disputes. It's usually a lot less expensive and there's a lot more certainty than going to court, even though a lot of these cases would be decided by a judge and not a jury. So we handle a lot of mediations on the front end. There are situations where my clients' contracts involve an arbitration clause or they're being sued or they have a claim against somebody and that party's contract involves an arbitration clause. In a lot of those situations, we're usually trying to get out of arbitration.
I have to say that your perspective on this was really surprising to me and very cool. I was like, oh, wow, this is different. So, but starting with the conventional wisdom, most of us think arbitration is good because, just as you described with mediation, it can be cheaper, faster, and have more predictability and certainty, but that's different from voluntary mediation is very different from a mandatory arbitration clause.
Yes.
So, which, I think, well, who would you recommend should have arbitration clauses, right?
Well, I think the general rule or understanding and the statistics appear to support it is that if you are a big business in a lot of contract dealings with consumers, that arbitration is going to be more favorable because you're going to be there frequently. So you're going to be the frequent flyer, so to speak. You're going to know the arbitrators. You're going to understand which way they tend to lean, especially because there's no record. So it's much more difficult in arbitration to get a sense of who is going to be more favorable, unlike court opinions where you can kind of formulate an idea of which way a judge is going to go or what they like, what they don't like, what type of cases.
We've all sent around that email that says, hey, who's been before this judge before? Can you give me a quick call and tell me what to expect? What are their inclinations? Yeah. So I found this article from 2015, which I thought was really fun, just even for the title, right? It's The Arbitration Epidemic. Mandatory arbitration deprives workers and consumers of their rights. This was a shift though, right? Because courts used to be reluctant to enforce arbitration.
Yeah, I think the current shift, which we're seeing in a lot of the Uber, Grubhub, Amazon cases, is that there have been exceptions to arbitration, and they are not upholding the arbitration agreements that these companies once thought were ironclad. So
the trend has been to shift away. I think there was around 2015 when that report was written, they were talking about how, they were being enforced almost all the time. But if, we go through the breaking news in the federal circuits, which we did get a decision from the Supreme Court yesterday, the last couple of years, we've seen a shift away, right, from enforcing these.
Yeah, I think that the Federal Arbitration Act has an exception for interstate commerce. that a lot of consumer and employee attorneys are sinking their teeth into. Consumer attorneys have always sought to find these clauses unenforceable because they're not favorable to their clients. But we're finally seeing some of the courts explore that exception related to interstate commerce, and we're seeing a lot of different decisions about whether, if you're just the last mile delivery driver for Amazon, are you engaged in interstate commerce? Does arbitration apply? And that's kind of tied to the class action waiver, because a lot of these attorneys want to, file class actions to vindicate consumer rights or larger class of employee rights.
Because that individual arbitration is often just not even feasible for the individual employee or the individual consumer. I thought one of the interesting things in these recent cases is that we seem to have this shift in the judiciary to say, we don't think it's fair to enforce some of these arbitration contract or arbitration clauses. But we've gotten a bit of a circuit split with the Seventh Circuit saying, with Amy Coney Barrett writing, saying, we are going to make them go into individual arbitration. We are going to enforce the arbitration clause. So we had the Third Circuit, the First Circuit, and the Ninth Circuit saying, you know what, we're gonna explore some loopholes here. And then, a new member of the sitting Supreme Court having written a decision going the other way. So we were all waiting with bated breath to see what would happen.
We were. I'm kind of disappointed that it didn't grant cert, because I did want to see what the Supreme Court had to say about these cases. There has been a split, and there's been a lot of discussion about what this means for class actions, for employees' rights, and how this will play out. So I guess we'll see where that goes. Maybe they'll grant cert on a future case.
So I'm curious, we've talked a little bit about the struggles that big businesses have been having, trying to, poor Amazon, poor Uber, well, poor Uber and poor Lyft, maybe yes, but, they're struggling to enforce their arbitration clause. What have you seen with the small businesses?
So my experience is that a lot of small businesses have arbitration clauses in their contracts, and they don't know why. It's just it's just something that people believe is the right way to go, and that it helps businesses. And they don't realize or consider, in most cases, what effect arbitration has on business to business contracts. So they're not specifically thinking about the service provider or your clients as a small business that are not consumers. So if your clients are other small businesses, what does that arbitration mean for you? Because we're not talking about the powerhouse versus the consumer anymore. We're talking about two small businesses. They're both going to be represented by attorneys. They're usually both very similarly situated. So if that is a benefit to big business, that certainly doesn't apply in the small business to small business context.
So talk to me about costs, because it's almost considered axiomatic that arbitration is less expensive. But you've talked about experiences where it's not. Give us details.
Yes, I think the first question is, where are you arbitrating? So there is the AAA JAMS arbitration administration, model, and anybody can go online, go to those websites and see the scale. And the scale for the admin fees, and we're not talking about the arbitrator's fees, this is the admin fees to get into arbitration or file a counterclaim in arbitration. All of that is public information. It's usually a sliding scale that's based upon how much is in dispute. And they can be thousands of dollars, many thousands of dollars, depending on the amount at issue. And, we're comparing that to court costs, where you're usually paying a couple $100, and that's it. That's the only fee that you'll pay. But you don't have to pay administrative fees in most cases in court, other than, your original filing fee. And you don't have to pay the arbitrator's fees or the judge's fees if you're in court. I mean, those are usually paid by tax dollars, but in arbitration, arbitrators can cost between $300-$500 an hour, several $1,000s to attend a day hearing. Sometimes they're multiple day hearings. I mean, you can spend a significant amount of money in administrative fees and arbitrator fees that you would never have to deal with in court.
Part of my experience back in Big Law days was that in arbitrations, and some of the arbitrations that I participated in were on the order of millions and billions of dollars, which, and between large entities too, not the consumer class action context. But I participate in a lot of discovery, right? The assumption is that there isn't any discovery, and certainly my experience has been sometimes there isn't. In a smaller context, you might get an arbitrator who's like, well, yes, we're enforcing this rule, there's no discovery, but also the arbitrators have a lot of leeway, right, to play with the rules.
They do. I think the general understanding is that there's less discovery in arbitration than there is in court, and that's what makes it move faster. But it really depends on what organization you're dealing with, what rules you're under, because they have rules, construction related, commercial disputes, consumer disputes. So it depends on that. And if you're going through a smaller entity, because, a lot of retired judges have arbitration programs that they've set up that people can elect to use. So, a lot of that depends on who you're going with and what the rules are for that administration.
Startup general counsel obviously is a slightly different audience because they're not always small businesses, or they're not always run as small businesses, right? Like even if you're an Uber or a Lyft, you might be still very early stage, but have enough venture funding that your initial startup general counsel might be dealing with questions of class action from either your independent contractors who think that they should be employees, or from consumers. So if you are heading a company that is not necessarily a small business, but also not necessarily a large business, if it's not arbitration is always good, what should we be thinking about when we're trying to decide whether to include that clause?
I think the takeaway is really to look at who's on the other side of the contract. I think a misstep that I would say I see a lot of businesses make is they have a blanket clause they use in all of their contracts. It doesn't matter whether it's a small business client, whether it's a consumer client. I mean, they just have a general idea that arbitration is going to be favorable in all scenarios. And I think that it's important to look at who is on the other side, to look at what arbitration company you're going to go with and write into the contract. And, recently I've seen that, companies have written into the agreement that, if they bring a claim, they can choose in that scenario which one to go with. They can choose to go to court, or they can choose to go to arbitration. So that may be something that people should consider. That's not something that you see every day, but it certainly piqued my interest when I saw that in a contract recently. So, as the person drafting the contract, I have the option. As the person who's signing, on the other side of the contract, they don't have the option. I'm telling them which way they need to go. So that gives you more flexibility if there is a dispute. At that time, you can make a determination whether arbitration or litigation is more favorable.
Brings into play the whole question of, are you drafting the template? Are you looking at someone else's template? Are they going to be enforcing this clause against you? Are you likely to be enforcing it against them? Does it go both ways? I mean, takeaway number one would be, I think, read the boilerplate, read the arbitration clause. Don't skip over it thinking arbitration is good.
And I also think certainty is something to consider. We didn't touch on that so much, but a lot of people believe that arbitration, you'll just go to arbitration and you will get a quicker result that's less expensive. But what we're seeing from all of these decisions that you listed in the prior slide, all of these companies are in court litigating over whether arbitration applies. So, they may lose that battle and end up in court, but they've already spent a significant amount of time and funds and energy on that issue.
I love the one. I mean, it just seems ironic and kind of funny that we've got a situation in which they are now in discovery in federal district court over whether or not they should be able to force arbitration or not, right, which is just crazy.
And it's already been appealed. It's been remanded. Now they're doing discovery on whether they're involved in interstate commerce. I mean, the amount, it's just, there is no certainty there. I mean, you haven't
Yeah, no
provided
certainty, and it's not cheaper. And now they're, depending on where they end up, ultimately, they might have to do discovery twice, right? And have it, yeah. So anyway, as we're thinking about it, you mentioned that there are different forums to choose, right? Where are you going to arbitrate, both physically and also under what rules? Under what circumstances will you arbitrate, right? That's the kind of tiered clauses that are, I think, a modification of what you talked about, where you can make arbitration or mediation non-binding. You can make it optional if the parties agree to opt in. That's one way to draft the clause. I've also seen tiered clauses where they say disputes over a certain amount, or in certain categories of disputes will go to arbitration, or will have exclusively jurisdiction in a local court to one of the parties. But I was kind of wondering what you think about when you're deciding as a litigator how to handle an arbitration clause that your client has a claim, now have an arbitration clause. What's your experience been with both complying with arbitration, and maybe what's your plan moving forward?
My experience has been, when my client is a plaintiff and they have a claim against another business, and they usually they didn't draft the contract that the other side is in breach of, that I will file in court and take my chances with trying to get around the arbitration clause, because there is certainty with getting a default. There's not as much certainty in arbitration over that issue. It's less expensive. We won't have to pay the higher filing fee. And there are a number of situations where they'll waive a right to arbitration by not raising the issue. They won't appear in the case, or they'll raise a defense that will preclude arbitration. So I usually roll the dice and take our chances and don't file an arbitration, even if I see an arbitration clause, because it usually isn't the most cost-effective, time-saving option for a lot of my clients.
Obviously the rules all differ, but that you have the ability to, take decisions about who the arbitrators should be. You can appeal that to the larger body. You could be fighting about who your arbitrator is going to be, when and where you are going to arbitrate, right? Even just physically, those are things that, in terms of, if what you're looking for is certainty, you can have a lot more disputes under some of the arbitration rules, which is kind of an interesting one.
Yes, I mean, and from my perspective, I don't think you see as many disputes about those type of issues when you're just going to court. Usually file a lawsuit.
You don't get to fight over which judge you're going to have.
That's not what you're fighting over. I mean, you see a lot of motions to dismiss about substantive or procedural issues with the complaint, but it's not so much about the issues that come up when you see an arbitration clause, and whether that's enforceable, and whether the Federal Arbitration Act applies, and whether they fall within an exception to the act. I mean, those are all unique to arbitration, which I think provides a little less certainty for the general counsel or the small business owner or the big business when they include these clauses in contracts.
The motions to dismiss, the motions for summary judgment are still things that often happen in arbitration. So it's not even an either or. It's like, let's fight about the process first, and then do the same kind of motion practice where we're spending a lot of time researching and writing about how it should work.
Yes.
So oh, sorry, go ahead.
No, I was going to say, and that doesn't even take into effect the discovery case that we talked about. I mean, not only are they filing about it, now they're doing discovery that could involve depositions and written discovery.
That's crazy.
Arbitration applies. I mean, it's just.
So one of the things that you've said to me as we've talked about this is that, you can always add it in later. What do you mean by that? Like, if you're a startup and you're trying to decide what to put in your contract, what do you mean by adding it in later? Do you mean, like, obviously you can't add it in this contract, but like, what would your recommendation be as we're, thinking about this?
Well, I think you see that played out in the Amazon case in the Ninth Circuit. I mean, Amazon is constantly making their drivers, in order to use the app, to be a delivery driver, they update the terms to their contract and they have to sign on to that in order to, they have to click a button and scroll down in order to continue to use that platform. So
like today I signed a certain terms of service, tomorrow I might sign a different term of service just to keep my existing job.
Amazon will update the terms of service and, you will, in order to, they make it difficult to opt out. I'll say that.
Yeah.
So as a general counsel, I mean, you can have your standard contract, but a lot of these contracts are renewed or updated or revised over time. So I don't think it's you make one decision and you can't change your mind. As the business grows and develops and your client base develops or changes, you can make a decision later on that arbitration, may not have been favorable at the beginning, but now is. And that's something that you can update when you renew your contracts or revise them. So
my takeaway in all of these discussions has been, we can't default assume that it's going to be cheaper or faster, or that it's there. The default assumptions are not correct. And so you have to make a more nuanced decision. And I'm curious, kind of, if it's your first time, you've just come from big law, say, as a insurance litigator, and you're now in charge of contracts because you're brand new startup GC, and you've got 17 contracts that you need to deal with, or even just one really extensive contract on top of all of the other buyers that you are fighting. What would your kind of quick and dirty advice be as they're trying to come up with, okay, how are we going to deal with the arbitration clause?
I would just do a little bit of research on what the effect of that is going to be in the circumstance. You can pull the sliding scale costs. You can compare what arbitration is going to look like versus your local jurisdiction. Are you in the Eastern District of Virginia where you're going to get a decision in 6 to 8, 9 months? Or are you in another venue where it's going to take 2 years? So you have to weigh that. And that's, easily accessible information that you have to weigh instead of making a blanket decision about, arbitration is good or bad. I would look at that. And I would look at, the time, location, and costs, are the big factors, and the certainty. I think I would add to that, what is the likelihood that you're going to face a class action? And that should be a consideration. What is, the likelihood that you may end up in court litigating over this? And what is the, cost of that?
So basically our answer today is there isn't an easy answer. You just need to make sure that you're making an informed decision, right?
Yes.
It's specific to the circumstances. I wanted to make sure that we included your contact information in case people have follow-up questions for you specifically. So that's shown here on this slide. I also wanted to let people know that we'll be sending around a recording or a link to a recording of this webinar in case anybody wants to share it with others or rewatch it themselves. I know we had a couple people email me this morning saying that they were going to miss it. Will there be a recording? Yes, there will be a recording. And we'll send that around along with also some helpful links that we used as we were preparing for this. So just stay tuned. As soon as the transcripts and everything are ready, you will get links to that. So thank you so much for doing this, Margeaux. I was so excited to get to talk to you.
Yes, thank you for having me. I really enjoyed it, and